Hello. Thank you for joining me for the office hours today. As always, please read the disclaimer in the chat box regarding legal advice and jurisdictional issues. Um, but I believe you are the first one in, so I will go ahead and unmute you. Do you have any specific questions today, or are you just here for observations?
Well, yeah, I was gonna just listen a little. I'm trying to. I'm still trying to write my response that you had started guiding me last week for their claim. I was the one talking about the claims. They're threatening to file the motion for contempt um, because of the well, a few grounds. But which one was I talking to you about? I think it was that he he took a lot of the property that he was not supposed to take. Um,
Oh, okay.
like he, my lawyer threw me under the bus at the last minute, and I had to give in on like buying him out of the furniture and the appliances in the house and that sort of thing. Which so I wasn't really a yes on it. I was forced into it, so it's like that's the straw that breaks the camel's back. Like I'm bitter.
Yeah.
So but then like when I realized he was taking so much stuff, and he would have taken even more stuff than he did. I had to have two people there with me while he was moving out to prevent
Mhm.
him from. And I think he also was planning to come back and steal more stuff after he moved out because he didn't think that I'd be able to like change the locks right away. I mean, like literally, as soon as he stepped foot out the door, my friends and I were got the drill out and changing the locks. And he did try to get back in because he's like, "Oh, I see you changed the locks." You know?
Yeah.
So I guess maybe a question I would have is, so I'm trying to, I'm not represented right now, and so like maybe a two-part question is, so I told his lawyer, and you had talked about maybe just trying to work it out directly with his lawyer. I told his lawyer first off that I was going to try to work it out directly with him. So
Mhm.
I did send him a few emails about there's quite a few issues that we're dealing with. So they had asked for some receipts. I sent those, and I addressed a couple of the more minor issues. I haven't sent yet a response specifically about the items that he stole. So I'm debating if I should give him the list. I know that's going to make him go through the roof, but if I send it, and he may or may not tell his lawyer, but if I send it directly to his lawyer, then at least I feel like it might give them pause, like, oh, they don't have a slam dunk case because they don't know anything about that he stole all this other property. Like they think that he abided by everything, and I'm just being, resistant to the order.
Mhm.
So I don't know. Do you have any thoughts about like the strategy of that, or?
Um, I mean, it's kind of contradictory because it sounded like you told his lawyer that you would work or you would reach out directly to him.
Yeah, that's true.
So yeah, but I mean, I don't think that like procedurally or strategy wise, I don't think it will hurt you if you then still go back to his attorney to kind of show them that these are the things that he removed. Um, it just kind of loops them into it. And if they were to show correspondence, because at this point it sounds like neither party's filed anything, you can show that you did try to reach or try to work together with them, which the court always likes to see the parties try to work things out of court first. Um,
Yes.
so I don't think it would hurt anything or leave you at a disadvantage.
Yeah, that makes sense. Thank you. Like, yeah, it helps to when I talk it out, and then when I talk it out, I don't realize what I'm saying sometimes, and then to have it reflected back, that's very helpful because right, I did tell them that I was gonna try to work it out with him directly, so I'll send him all the information directly,
Mhm.
and thinking right, and then that gives me the chance to say, even if it were to make it to court, to say not only did I try to work it out of court, but I tried to work it out without having him incur even any more legal fees just from his own lawyer, because
Yeah.
he's done the reverse, like trying to drive up my legal fees.
Yeah. And if you reach an impasse with him, then you could then loop his attorney in too. So you could try like all the ways, like try with him. If he rebuts you, then you can loop his attorney in and say, these are the things that I have issues with or that he's not compliant with. I'm hopeful we can work together on them or something along those lines. And then the third option would just be filing a petition for contempt.
Right. Okay. Yeah. Okay. I like that plan. Yeah. So like a 3-phase plan, like check the lowest level of escalation. Okay. So, and I think like I'll try to offer him that, because I did make the first payment. It was like to pay him in installments. I did let him take the first installment out of the child support because I hadn't had a chance to like think it through yet. So I was thinking to offer like, okay, you can keep that first installment and deduct like some of the things that he's saying I owe him for like the kids' activities and stuff like that. Like he can keep because technically he decided on the activities unilaterally. So I think, I could fight him on that, but I would say like, okay, as a compromise, since I already gave you already have that money, instead of me saying like, now you have to even give me back the money that I already gave you, which he definitely will not like. I'll say, okay, let that be the fund for, I do owe him money for like the health insurance and that's legit, the health insurance cost. I mean, he gave me the wrong cost, but I do have to pay him for that. And say like, then the rest of the money, why don't we just leave that as that'll be the fund for my share of the extracurricular activities, going forward until that runs out. Does that sound like there would be like not to do that, right? Like no like legal reason to.
No, I think that sounds great.
Yeah, and it's like it will appeal to him because he likes to be in control of the money, he already has it, so
it'll make him feel like a win.
Yeah, and right. So I just have to. He has some of the calculations wrong. So yeah, it's the some of them are minor issues. That's the main one, is that he took more of the property. He's going to say, that he had a right to take all that property, but I'm going to say, look, the judge has to go by the letter of the law, and the way this is spelled out in our agreement says you're only allowed to take your personal items, personal effects, and personal clothes. Now, from what I'm seeing from my research, there's a legal definition for one of them, but not the other. I get them mixed up. So like say there's a legal definition for personal items, but not personal effects. Like that's a little more ambiguous. Do you have any like familiarity with those specific terms when they're left ambiguous?
I think it's very discretionary up to the judge that's interpreting it. So it depends on what exactly he took. Like if it was something that was an item that was purchased during the marriage that was used by everybody in the household, then I don't think that would be a personal effect or item. But if it was something that was either given to him, I mean, that would be a gift. So that would be his sole and separate. If it was something that was purchased just for him to use, like I don't know, like some piece of furniture to store, like maybe like a watch box or something, that would I think be considered like a personal effect of his, or like his own family heirlooms. But if it was like, oh, well, I want that couch, that's not his personal effect.
Right.
So I guess it depends on what it is.
Yeah. And it was the wording says, and any other personal property becomes my property. Like, so, and it specifically says all furnishings, all appliances, so he took furnishings and appliances, like small appliances. I'm talking about, like a, dehumidifier, an air purifier, stuff like that. Air conditioner, like a small, like stand-up air conditioner type of thing. But things that I would still need for the basement. And then he took, like some chairs and shelving units, which that I really wanted. I specifically told him you cannot take the shelving units, and he took, 4 shelving units. So like that's clear.
I don't think, none of that would be personal effects. I don't believe.
Right. Yeah. I mean, it was like literally like to organize the basement and the garage, like it was not a feature of the house as it wasn't built in, but it's like it was for the purpose of organizing household items, like not his personal stuff. And he ripped out the stereo surround sound system out of the walls and the ceiling of my living room. I mean, you can't say that that's a personal effect. I don't think any judge would say.
No.
And he also took a desktop computer that he had given me. He took the tower and the monitor that was on my desk, on my desk in a separate area of the basement, not in his area of the basement. That's, a substantial.
Yeah, I would put all of those in a list of things that he wrongfully took and that are not compliant with the court orders.
Right. Okay. Yes, I'll say yes. Not in compliance with the court orders. Mm-hmm. And then the other main thing that he's fixated on is the silver, which I had run that by you. And I think something you said that was very helpful is that he might call his mom to testify, because I said I think he took it to his mom's house a long time ago. So I'm thinking that I just won't be specific. I'll just say I don't know. I really don't know what happened to it. I was just, assuming that because he's done that with other things. I'll just say there's no way that I could know what happened to it, because in addition to him stealing those items, the stipulation also states, which he also violated, that he was supposed to allow me to be present when he was removing any items from the home, and he did not. He purposely did it either when he knew I was not home, or he did it overnight when I was sleeping. Not for all of it, the stuff that he was, smuggling out. Obviously not when he came with the, his nephew to help move some stuff out. So he violated that part. He did not allow me to be present. And he actually locked me out of his portion of the basement for 2 weeks before he moved out. So I'm trying to figure out how would I word it that those are breaches of the agreement, and they prevented me from knowing what he took or didn't take in terms of the silver. But I don't have the silver.
Yeah, I would try to find some way to correlate it where it's like he removed so many things that he was not entitled to remove, and for all you know, he already took it because he took so much other stuff that he wasn't supposed to take, and you've done your due diligence looking through the house for it and you haven't found it, so you just assume he took it with him when he moved out.
Oh, okay, that's really good. Yeah. Okay. I see there's someone else here now, so I'll let that person go. And if I have any other questions, if there's time at the end. But that's really good. And I still haven't found the recordings for these. I have to go back and write down all that. It's hard to write it down. But thank you. Thank you.
Of course. Hi, Beth. How are you doing today?
Hello, Laura. I'm pretty good. So I'm going to court for a modification middle of next week. And this was requested by my ex, and it's all about him paying less money. We've handled about half of it, and the last piece he postponed till a week and a half from now. The point of the postponement, I mean, I knew it as it was coming down. He's about to get married. They were trying to buy a house. So they were waiting for me to refinance, and then they're buying. Let me close my door a second. My daughter started to play her trumpet.
No worries.
So the only piece is this $350 a month for spousal support. But he's just bought in the last month a $1.5 million house, which in Los Angeles doesn't really amount to much, but it's still twice the worth of my house and the house that we had when we were married. So my questions are, I sort of thought I knew what I was doing until I got the financials, and it said exactly what I thought it was going to say, but now I've gotten myself all worked up. So I just want to sort of calm myself down. Number one, I turned in an updated or amended income and expense report.
Okay.
I think I made a couple of mistakes. Number one, where it asked for real estate, uh, uh, I put the whole worth of the house as opposed to the worth minus what I still owe on it.
Okay.
And then I added all the numbers up, and it came out to that my budget, my expenses are 10K, but I know that's not true, but I know all the individual numbers are true. Um, and I think the problem is, and I don't know if it's different in Arizona than California, but it lists the mortgage and then it has the principal and the and the interest, which you don't add in. But then it also has the escrow and the insurance that you do add in. But that's all included in my mortgage payment. So my worry is that if I go back and correct it, because this was the first time through, I had a lawyer when we started this about a year ago, and I had said something about this then when I'm looking back at my notes. So that first one also had the same mistake in it. Does that make
Okay.
sense?
Yes.
If I change it now, it's gonna not show that when I refied it went up $600.
Okay.
So I'm a little worried about fixing it. Now it says I've got a 10K income and our expenses, and I'm making about 4K, and that doesn't make any sense. But yeah, I'm just don't know how to make it all make sense.
I would file an amended one or a new one if they just have you submit a brand new one and just correct the information. And then when you go to the hearing next week, you can explain what the differences were between the first one and this one and just let them know why you did it that way and that you were just trying to update the information. You wanted the court to have the correct information. You're not trying to double dip essentially because I think that's what you're saying where it asks for your mortgage payment and so you give the whole thing and then there's a separate section where it has you break each one down and it's adding all of those together. Is that what happened? Yeah.
Yeah.
So I would fill out a new one and then if the court asks you or when it is your turn to present your case, I would explain exactly what you just explained to me that you like if there was a refi and your house payment is now different, like explain that and explain the differences because I mean, if I were interpreting somebody's financial document like that, what I would do is ask the person why they made those changes, what changed if they hadn't moved, why are the expenses now different? And so then you'll just have a chance to explain to the court why you revised it.
Okay. Um, and then on his, do I with this just little amendment thing, do I also do a response to his income and expense?
That I'm not sure about. I think that might be jurisdiction specific, but in Arizona, when somebody files their financial information, there's no responsive pleading. It's just here's my financial documents, and then you address it in court through testimony. You ask them questions about what they put on there. It might be different in California, like if is it like any kind of notice that's given or how is the financial document provided to the court?
It's just provided to the financial document is just, it's just a form. You fill it out and you turn it in. Maybe it has attachments and such, but that's about it.
Okay. It doesn't sound like it's the type of pleading that you would file any kind of response to.
Okay. So where do I just prepare in the court to be able to say, what I want to be able to show is that he's trying to not be responsible and he's trying to move on with his future wife and live happily ever after. And I don't want to, I wish him well. Great, that's fine. But not by not being responsible to what he's supposed to be responsible to.
Right.
the process he went through was when we made the plan for the spousal support, it goes till about 6 months after my daughter turns 18. So I've got two kids. One finishes high school. That amount goes down. Second one graduates. That goes down. And then I've got about 6 months before with $350 left to, so it all made sort of sense, right? I'm self-employed. COVID had damaged my work, and I'm slowly growing that back up again as planned.
Okay.
So my job is to show that I've been doing what I'm supposed to do, and that this was a reasonable plan that we created based on the length of our marriage, blah, 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 right?
Mm-hmm.
But I also want to show, I think, that he brought this at a point in time when he was moving in with his fiance. So he had a $3K rent when he started creating all of it.
Mm-hmm.
But he used the amount he was going to pay when he was with when he moved in with his fiance, which was at the date of the court date. That would all make sense, right? He used the future amount, but it went from 3K to 18K, and then he's asking to not pay spousal support because it's such a financial strain when he's just given himself $1,200 extra to use a month. So, are you with me? The point is that he was paying 3K, and
Okay.
then right before court, he was paying 18K for rent.
Okay.
And then a month after the court, he stopped paying child support, so that's another $700 he wasn't paying.
Okay.
So he's got 19 less in expenses, while he's busy saying he can't pay me $350 because it's such a financial strain.
Okay. Is he paying $1,800 a month in rent?
Yeah.
Okay, so you said 18K, so I was.
Oh, sorry.
18,000. So that's where the math wasn't mathing.
No, it wasn't. No, I understood.
So that makes sense. Yes. So basically, you have to show that you still have a need for the spousal maintenance, and his job is to prove that he can't pay the spousal maintenance. And so if he's showing that his bills have actually lowered and his income has stayed the same, then he likely won't meet the burden of proof that is needed to show why it should change.
Well, the big change now is he saved 24K over the course of a year, and then used it on a down payment of this house he just bought with his fiance. So now he has an $8,000 rent mortgage a month.
So does his fiance work or contribute to the living expenses of the house?
Yes.
So that's another way that you can attack it, is to say, even if his financial situation has changed, like his income hasn't changed, but his expenses have gone up now, you can try to say that he has other support from the income from his spouse, to show that that is also helping with his monthly living expenses.
Mm-hmm. Well, he did claim that she's paying for part of it.
Yeah.
So I happen to know that she makes twice as much as he does. So
yeah. So she might be covering more of the rent,
mm-hmm.
or more of the mortgage. With the hearing being next week, I don't know how much disclosure and discovery has been done. Like if you have access to his bank statements that maybe show what he is contributing. If not, I would just argue like that she makes more. She's obviously covering more of the expenses. Mm-hmm. I would go back and say he was paying $3,000 a month, and still meeting his obligations. So if he is now choosing to live in a more expensive house, we don't know how they're sharing the expenses. That's not your job to figure out. And he should still be paying you the same amount. It's those kind of arguments are kind of difficult to make without knowing what the burden of proof or the threshold is for the certain jurisdiction. But just theoretically, like those are the kind of arguments that I would be trying to make.
Right. Yeah. Okay. Perfect. Thank you.
You're welcome. Thank you.
everybody else. There's somebody else. Never mind. I'll leave it be.
Hello, do you have any specific questions, or are you here just to observe?
Me?
Yes.
Hi, sorry. No, I actually do have a question. I didn't want to interrupt.
Oh, no, you're fine.
I'm based out of Florida. I have a lot of dilemmas apparently, but when I got divorced, I always thought that I was supposed to pay every month, but apparently for the past 8 years, it's supposed to be my ex-husband. So we're back in family court. The problem is he turned in his financial affidavit. Mind you, he's an attorney that owns his own law firm, and claiming to have zero assets, which I know isn't true because I printed out the property value of his home and his wife, who's also an attorney for him.
Yeah.
So I'm like, I don't understand how the courts will allow the type of perjury. I'm told by my lawyer, oh, we can only prove it when we go to trial, which is another $15,000. And now he's also refusing to even help me to get our kids to and from school. He demands I do it and drive to his house to do that too.
Mm-hmm.
But the thing is, like, I can prove that he's lying, but I have to wait apparently till trial. And I'm just kind of confused because how can you claim zero assets if you own a home?
Yeah, I mean, I would see if there's other discovery techniques that you could use to try to get additional information, because I mean, he has to qualify for a loan for the mortgage and show some kind of income. I don't know if he's required to disclose his.
Oh, he was supposed to. Mm-hmm. He never did.
I mean,
I exposed all mine for 3 years worth. And one of them was a loan under his brother's name now. His brother, after a decade of paying it, stopped paying that too. So now I'm stuck on the hook for that as well. So I don't understand why courts don't view this financial and coercion even that it matters. I don't understand how it doesn't.
well, I mean, on its face, it's not necessarily perjury. You have to show that he's lying. And in Arizona, the family courts don't really seek out perjury claims. Like somebody else would have to notify the correct authorities of that, and then they would decide whether or not to pursue that. Because he is a licensed attorney, though, if he's not following court orders, not complying with disclosure rules and things like that, I mean, that's punishable by the state bar, and he can be subject to sanctions professionally if he's not complying with certain things. I mean, here in Arizona, if an attorney is not complying in their own personal family court case, they can be sanctioned by the State Bar of Arizona. They can be put on probation, things like that. So there are penalties that might be available that don't necessarily involve your court case, but that still could maybe push him to start complying with some of these things. And then
he's not one to comply, I'll be honest.
Well,
I see it, baby.
With regard to the exchanges, if there is a court order saying how those exchanges are to take place, you should still be able to do some kind of enforcement action before your final trial to make him comply with those. It's usually something that can be filed at any point in litigation, or even if there isn't any litigation, you can do a petition to enforce.
No, we tried that already, and he already filed 5 motions of contempt against me in 3.5 months in 2 different courthouses, because our parenting plan is, I'll be honest, horrible. It doesn't specify dates or times. It says days of the week, and only 2 times at the state a time. 7 a.m. for him and 7 p.m. for both of us, alternating weekends. He's never ever picked up our child except for 2 times last year from school, because our parenting plan is silent on school transportation. So he is purposely wiggle worming his way out of everything, and has already informed me via text that he will pull our child out of school that he's been at for 4 years, and we'll sign him up to school by him because he will not do my driving anymore. I've already filed a domestic violence. I already got denied. I reapplied again today because that text was sent to me yesterday.
Okay.
I'm over the whole system, to be honest with you, because it's horrible.
Yeah, it sounds like maybe like you do need to just wait for the final trial then so that the court can put firm orders in place that you can enforce.
But then what
It,
do I do if he refuses to take our child to school starting next week? He said if he has to pick up our kid from my house, he will not take him to school, and I will be in trouble because I refuse to pick him up 30-minute drive to his house to come back and take our child to school by my house. So what can I do for that? Is that going to
I
look
mean,
bad on me?
I would just try to keep the status quo. I mean, what grade is your child in?
He's going to fourth. The status quo used to be his mother used to do it on his days. After I refused a last-minute makeup thing, he threatened she wouldn't help, and sure enough, she stopped helping. So I've been having to do that while working 12-hour shifts.
Okay. I mean, it's kind of hard to advise in that situation
Yeah.
because I don't know what your specific orders say, but it sounds like it doesn't say, like, it's presumed that during each parent's parenting time, they are responsible for getting the child to and from school. And so if he is going to stop taking him, then that's kind of a child welfare issue where then you should just have your child most of the time if he's going to act that way. Then if he tries to say that he is going to select a different school, depending on what your orders say regarding how
It
you
says
guys.
my house, my residence.
Okay, so then he shouldn't be able to change the school.
Oh, and I
Um,
don't think he can. It's just like these threats of trying to, once again, put our kid in the middle, which is,
Yeah.
since he's a lawyer, he's trying to manipulate it, saying I would be in trouble for not driving to his house to pick up our kid to take him to school.
So he's trying to say that you have to take him to school on his parenting time days?
Yes, and
Yeah.
or deliver him to his house on his parenting day, one or the other, because if he's obsessed with a 50-50 driving, meaning that he wants me responsible 5 days during the week. He doesn't want to be responsible. I have to email and everything to prove it.
What's your parenting time schedule?
Monday, Tuesday, Monday, Wednesday. We did it. I'll be honest, like 9 years ago, so it's horrible. Monday and Wednesday is his days, and then Friday, whoever's weekend it's not, has our kids till 7 p.m. And then we pick up, but he doesn't pick up our kid from school on Fridays.
Okay.
He waits for if I'm at work, he waits for my husband to pick up our son from school, and then so he doesn't have to go in the car line. He picks up from my house, so me or my husband have to go back to his house at 7 p.m. Where on Fridays that are his days, I just let him have him instead of bouncing the child around.
Mm-hmm. So on the days that he is supposed to start his parenting time and it's a school day, why? I mean, if there's no orders and he leaves the child at school, and
I can't do that to my kid, though. That's the thing, and he knows it.
No. I mean, like, you should go get him and then take him to your house. Like, if there's no orders about how the exchanges are to occur, you've made him available for him to pick up. And so if dad's not going to do it, you can't just leave your kid sitting at school. You're going to go pick him up. And then it puts it back on dad to come pick him up from you or to get him from school.
I know, but he's threatening that if he has to come to my house to pick him up, that he will not take our child to school in the morning.
I mean, then if that happens, I feel like that's just one more thing that he's doing that's not in the child's best interest, and it's going to look bad on him.
I know, but when does it start looking bad? That's the problem. Like,
at the trial, at the final trial. So I mean, is there litigation that's going on right now for a modification?
yes, we have a trial date, not until December, because they always try to delay stuff. So
yeah. So I mean, it probably would then wait to be addressed at that hearing in December. And so unfortunately, if that's the way Florida works, like, it's just kind of a free for all. Like, you're not able for violating something that doesn't exist, just like he's not. So if
my question is, would I get in trouble if I don't pick up my kid in the morning to take him to school?
I don't think so. I mean, it's hard to
right?
say.
It's hard to say. I know, that's why it's like a gray area, and I hate putting the kid in the middle.
I think the person that it's going to look bad on is dad.
It's him. That's what I thought.
Yes, he should be participating. He should be doing it. And if he can't, then the parenting schedule needs to change, and the child should be with you more often.
I'll keep him every day of the week, and he can have every other weekend. But he also he wants every weekend, so he doesn't have to do that, which I don't want that. I want to have my weekends also every other. I don't feel like I'm asking for much.
It's hard to say. I mean, depending on his availability for weekdays, that back and forth exchanges like Monday, Wednesdays, those are kind of weird. I would try to, if he wants some weekdays, like make it closer to the weekend, like give him Thursday, Friday, Saturday, Sunday, every other week or something like that to give him additional time. And then he doesn't have to drive every day. It would just be 2 days per week.
No, I
Um,
offered that. I offered like maybe he could do Monday, Wednesday, Thursday, Friday, 1 week, and I'll just pick him up from his house like on that Saturday morning to start my weekend. But
mhm.
we won't take it. He wants every weekend so he can avoid responsibility.
Yeah. I mean, I don't think it's going to look bad on you if you don't go pick him up to take him to school. I think it looks bad on father for doing
Yeah.
that.
Okay.
So,
Sorry, I just wanted to. Sorry to take over the conversation.
no, you're
I'm
totally
just
fine.
frustrated.
No, you're fine. It's open for everybody. So I think there is a question in the chat. Let me just
Okay.
see. Okay. Um, not seeing it. Oh, okay. Thank you. Found it. Okay. So what do you suggest in terms of a step-up plan for supervised visits? I am not getting unsupervised, but it has already been agreed to be transitioned. The other parent is not allowed it, but refuses to allow me to do outside the home visit, and I am not sure what to expect in regards to the situation. I'd like to find a solution that would allow me to get better relationship with my daughter, but no other turns. Okay, so generally step up or gradual increasing parenting plans all can look very different depending on the circumstances of the case. So since it sounds like you have supervised visits right now, the court usually will do about a 3-month period of, anywhere from 2 to 3 months per phase. Um, Depending on what the severity of the issues are, if there needs to be like reunification between the parent and the child. So I would expect um, some regular contact 2-3 times a week of supervised visits. Then once those are successfully completed, then the court will introduce unsupervised, probably for the same amount in duration, just to not make any huge changes. And then after that, it would gradually increase to like a full day or an overnight, and then increase to like 2 overnights, and then potentially an equal parenting time schedule. But again, the circumstances of how fast that goes are all different. I've seen them be a year long. I've seen them be 6 months. I've also seen them be as short as 3 months. So it really just depends on what the issues are that are present. But then as far as like where the supervised visits take place, those should be anywhere. There are supervising agencies that will meet you in public. They'll meet you at a park, a restaurant. They'll come to your house. They'll go with you to places so that way if you do have a long period of time, you don't have to be stuck doing one activity for that whole time. And depending on the supervisor that you guys either are forced to use or choose to use, if it's a family member, you certainly should be able to leave the home, unless there's issues with the supervisor and like health issues or anything like that. But typically supervised visits are not restricted to a home or facility. You can go out and do other things with the child or children. But yeah, that's kind of how it would look. I mean, if there are more issues with maybe lack of not contact between the parent and the child, then they might be a slow, gradual increase. Or if there's been issues with substance abuse and there's ongoing testing being done, then the court will typically want to see some negative tests before they move to unsupervised time. But even with drug or alcohol concerns, as long as there's regular negative tests that are occurring, the court will usually allow the parenting time to remain unsupervised, as long as it's not overnight or anything like that. So it really just depends on the situation itself. Does anybody else have any follow-up questions?
I had one.
Sure.
So in me trying to show that he's just trying to save himself money, not that it's a financial strain.
Mhm.
My daughter just spent 2 weeks, the first 2 weeks she's spent with him this summer, and it was, vacation, and he didn't have anything planned or anything prepared for her, and wouldn't drive anywhere, and they walked to a couple of places, and yet he's got $700 of entertainment and vacation and gifts listed on his thing that he does per month. It says, would it be petty, snarky, not look good if I say, well, if he's spending that amount of money a month, then either he's not spending that amount a month or he's purposely not spending it on his daughter?
I see the argument that you're trying to make, and I think it could be a good one depending on how it's presented. Um, and I think maybe the better approach would be to say that he has that listed as an expense, but throughout the last year, you haven't heard of him taking your daughter on any vacations. Um, they haven't gone to any, I mean, I would try to be specific, like they haven't gone out to dinners, to movies. You're not sure what, there doesn't seem to be recreation that's occurring when your daughter is there. And so this is just a personal expense that he's using for himself, and therefore he has the ability to still spend half of that on your support payments. Because it's $350 a month, right?
Right.
Yeah. That's how I would try to present that.
Let me say that back to you. So, being specific, over the course of the past year, it has not been apparent that he has been spending any portion of that amount on when my daughter is present.
Yeah.
With specifics.
Yeah, like he has taken her on vacation, and so this is just a choice that he's using to set that money aside for, but it's not benefiting your daughter, it's only benefiting him. I don't know how far that argument will go with the judge, but I think that they will kind of see that he has this discretionary money available that he's trying to set aside for vacations that don't exist.
Sorry, quick question. Would that also apply to a man who's bald, saying he pays over $100 a month in grooming?
I mean, does it potentially, if he goes to like a barber to have his head shaved or something, like they could try to say that. I mean, it should be as simple as you just.
Okay, I was just curious. Yeah.
But I do know that some of those places can be very expensive. So if he is like treating himself to like a nice hot shave or whatever it is, I would still argue that it's an extraordinary expense that he doesn't have to have. But yeah.
Thank you so much.
Yeah, of course.
There was something else on my mind about, and I've lost it. Just give me half a second if somebody else has something they wanted to say.
No problem.
I do have a question actually about the financial affidavits. I'm not quite understanding it. It's probably different in every state. But it says it include health care for child or children. But I do have another child that's not with him, thank God. But I do have another child, which I do cover health insurance for my whole family. Do I
Mhm.
include the amount I pay for her and our mutual child, or just our mutual child?
So the way that we do that in Arizona is we look at what the employer breakdown comes out to be. So they usually have a form. Every employee, like HR department, has one where it says employee only, employee plus spouse, employee plus children, or like whatever options they have. And then we deduct it from the employee only one to come up with the amount for just the children. And then if there are multiple children covered by it that are not common to the parties, so if you just have the two kids, you would take the amount for employee plus children minus the employee cost, and then that's the cost for the children's coverage, and then you would divide that by 2, and that's how you would get the cost for just the child that you share in common. But again, that is specific to Arizona. Some jurisdictions might do it differently. So I would include both. I would include in a lot of those forms, at least here, you can write on them to kind of explain how you're getting these numbers. And so I would advise you to include all of it so you can show what the amounts are, where you're coming up with these numbers. And then if the court does just give you credit for the whole portion of it for just one child, I don't want to jip you out of that, because I mean, the coverage, even though it covers 2 children, it still would be the same if it was just one child. So it is possible that the jurisdiction gives you credit for the whole amount.
Okay, yeah, thank you. So what I was doing is I do a family plan. I was just dividing it per person because it's a family plan. I saw something online that said that, because I know I can't include cover for my stepchildren because they're not my biological. I just wanted to see that at least for my 2 biological.
Yeah. I would, again, it different jurisdictions, so you could include a breakdown that way as well. But I would make sure that you do account for anybody that's covered on the plan. So if your stepchildren are on the plan, you would have to include them too, and then allow the court to determine how they apply the amount of the cost to each child, or if it's
All right.
one.
Thank you.
Yeah, of course.
I remembered.
Oh, okay.
So he's getting married, and there's nothing in particular on his income and expense that says wedding expenses. Now he could be putting that into the entertainment vacation portion. That it could be that's all. You know what I'm saying?
Mm-hmm.
Do I mention the wedding, or do I leave that out of my discussion?
I would personally leave it out of the discussion. I feel like the more, even though I don't believe that this is the case, the more that you reference the wedding, the more it's possible that the judge could see that you're just upset that he's getting remarried, and it's not a regular recurring expense that is going to be accounted for purposes of maintenance, or support. So I wouldn't give him the benefit of the doubt and say, oh yeah, it could be this. I would not bring up the wedding at all. I would only she went away. I would just bring up the fact that they now have shared finances. Okay, question in the chat. How would you approach parent refusing to return a child at the end of vacation, stating that the parents agreed he could stay the whole summer? There is no agreement, and parenting plan says dad gets every other weekend. Dad also moved to another state and has not informed mom, though the child did. So that I would certainly do a petition to enforce and request make-up parenting time. If he's moved out of state, he is still required to comply with the current parenting time schedule, even if he has long distance parenting time already and is essentially agreeing to continue that. But I would probably do a petition to enforce the parenting time, and then maybe a petition to modify together, and get a more concrete long distance parenting plan put in place. So that way this doesn't become an issue again in the future. Because right now, I mean, he is in contempt for not complying with the order and not returning the child, but he probably will continue doing that kind of thing, um, unless there's court orders in place that have a clear parenting time schedule now that they're out of state. Did anyone else have another quick question? I think we.
Sorry, maybe one last question. I'm sorry. All right, another question. Since I have gotten remarried already a while ago, do I have to write my husband's house that he had premarital, that I'm not on the deed on? I don't even pay the mortgage. I only transfer money for bills every month like clockwork, and wouldn't even share any bank accounts because we both have exes. But do I have to include that since it was premarital property? He had it even before our mutual child was even born.
That would be really form specific. It depends on what it's asking. If it's asking for
assets,
well, if it's asking for your assets, then that's not your asset. So I would not include it.
Mm-hmm.
If it's asking for like a mortgage payment and you don't have a mortgage payment, I would not include it.
Yeah, I don't. Yeah. I always left it under him because that was his before me. So I just wanted to double check. And I didn't want my ex ever trying to go after my new husband's stuff.
Right. Yeah. I don't think it's required. But I would just read that form really carefully and make sure.
No, it said mine. I read it and I looked it up also. But I figured I had you on the phone, I'd ask you. But that's what I keep seeing and reading. Thank you.
Okay. Yeah, of course.
I have a couple of quickies, I think. That's okay. If I have to file a motion for contempt, I'm in New York. I'm looking up templates. It seems pretty straightforward in terms of just documenting the facts. Like, do you think that's something that's doable, self-represented, or?
Yeah, absolutely. I think there's some statistic like here in Arizona that 90% or maybe even higher of cases are filed pro per in Maricopa County, and that means by themselves without an attorney. And the forms are pretty specific. And especially for contempt, because you just put in what the current orders are and how the person violated it. And then once you get a hearing, then it's your burden to prove how they violated it. And the other person is required to defend against it. So to get the process started, it should be very self-explanatory if the court forms are helpful and how to where to put the information and things like that.
Right. Yeah, it seems that way. Yeah. And then, so I have photos of the property in my house before he took it, and photos of the same space without the property. I mean, I guess he could say that I removed would that be really proof? Or he could say, he could say that I removed the property. I do have a couple pictures of his putting it in the truck, but not all of it.
Right. Yeah, I would, the way that I would attack that is to say, yes, you could have taken those at any time. It's hard to prove. And then you would want to testify that they were taken as soon as he moved out. You went in the house and saw that he removed all these things and you took pictures. So if you had timestamps on your pictures, like they were taken from an iPhone or something, then that will help you, because then you can show exactly that it wasn't taken just yesterday. It was immediately after he moved out, and you're documenting that he took more than he should have.
Right. Okay. Yeah, I do have the timestamps. That's a good point. And then I know this may sound petty, but because he's nickel and dimed me into, being in huge amounts of debt and stolen, large sums of money for me. So I do have to pay him back for portion, he paid for my health insurance in between when we signed the agreement and when the judge signed the order, a couple of months. But he's paying for that with pre-tax, salary deduction. So really me paying him back dollar for dollar is almost like giving him, 30% or whatever on top of what he paid. Do you think I could argue that I should pay only his net cost? Or, and it really is the same every month for the kids' health insurance also, but I won't get into that because that's
I don't think so. If it's part of your orders or your agreements that you were going to pay him back a specific amount, then that number is not able to be changed unless you
Yeah,
guys.
we didn't know the amount ahead of time. Like he just, and he calculated it wrong. Anyhow, I'm gonna fight that part of it, but because he charged me double for the kids portion. But okay, so that, and then when I'm writing up the letter to him, where I'm documenting all of this, I know I should probably stay as neutral as possible. Like it's hard for me to write it without saying like, because you were abusive and this is like would I include that this is your long-standing pattern of abuse and control, or you know what I'm saying? Like I might want to put that in for the court, but
I mean, I would just keep it to the facts of the case. You can go into more legal argument or persuasive arguments later on. Typically, in Arizona, after a hearing is set, you can file a pretrial statement where you outline your whole position for everything. But
okay.
the initial petition to get your foot in the door, I would just keep it very like, this is what the order is, and this is how he has violated it, and then whatever relief you're asking for.
And like when I'm sending like letters directly to him about the items, like because he, long story short, there were some tickets he was supposed to give me that he was just playing games, and he refused to give me the tickets. So I ended up getting my own tickets, and he still wants me to reimburse him. I mean, obviously he knows what happened. So like, I guess thinking in terms of those 3 phases of like first dealing with him, then his lawyer, then the court, like, do you have any like just thoughts on like, should I just word it all the same as if I was gonna then take it from him directly to the next phases, or
Yeah. In all your communications with him, you should anticipate that the judge will see it. So that way it helps keep you in, and I don't mean this in a negative way, but
I'm a hothead
case, and show that you are reasonable in how you're reaching out to him about these issues, that you're not trying to like drag a bunch of stuff into it, and you're not trying to provoke him. You are just trying to resolve the issue.
Yes. Okay. And that's a great thing to keep in mind. Like, assume the judge will see anything.
Yeah.
Okay. These are more sort of a formal response to like his, even though I'm not responding directly to his lawyer, but it's a response because his lawyer sent that formal letter to me. So, okay.
Yeah.
That helps a lot to keep that in mind. Thank you very much.
I really hope to God Joan, because I have some doozers of ones. Please, because I'm keeping my side of the road clean.
Well, I think
Laura,
yeah.
I lost connection there for a second, right when you were answering my question.
Uh-huh.
You said I shouldn't mention the wedding just because it'll make it look like I'm against the wedding. Did you say anything more than that?
I just said I would focus on the fact that he has this additional support, financial support in his household every month. And not even mention the wedding.
Great. Perfect. Thank you.
You're welcome. Well, thank you everyone for joining us today. It was a pleasure speaking with all of you, and I will be here every Monday if you want to join.
Thanks.
Thank you so much. Really appreciate your help. Thank you.
You're welcome. Have a great day.